Right, when an employee is accused of misconduct, however serious that misconduct is, there's this process to be followed. An employer has to make sure that they follow their own disciplinary policy, but also that they comply with the ACAS Code of Practice. And there are 3 key stages for any disciplinary process. And the first is investigation. So firstly, you need to appoint an investigating officer, and they need to fully investigate the alleged misconduct. However blatant or obvious that misconduct might first appear, you have to investigate because there might be some explanation for it that you haven't even considered. So the investigating officer will first have to speak to the accused employee and find out their version of events, but also to speak to any witnesses who might have relevant evidence and consider any documentary evidence which might be relevant, such as timesheets or emails. Gather all that evidence together, and the investigating officer should have no preconceptions when they go into it and should consider all possibilities. And at the end of the investigation, they need to decide whether there is a case to answer. They don't need to go any further than that, so the investigating officer shouldn't decide whether the employee needs to be dismissed or whether they're guilty, just whether there's enough evidence to suggest a case to answer. If they think there is a case to answer, then the matter will then progress to the second stage in the process, which is the disciplinary hearing. At that point, ideally, if the company is big enough, then somebody else should take over, a disciplinary officer. The first step for the disciplinary officer is to invite the employee to a disciplinary hearing. And at that point, it's really important that the allegations against the employee are very clearly set out in the invite letter. So don't put a vague allegation such as you're accused of breaching company procedures. It's not sufficient. The employee needs to understand the case against them. So the employee needs to know what procedure they're alleged to have breached and how and when. And that all needs to be set out in the disciplinary invite letter. The employee should also be given all of the evidence that's been gathered as part of the investigation before any disciplinary hearing. So they should be given the witness statements, the signed witness statements, any other documentary evidence that was considered, emails and timesheets, and maybe CCTV evidence if that's been looked at, so that they have everything before the disciplinary hearing and they can properly prepare for it. The other thing that needs to go in the disciplinary invite letter is a warning to the employee if there is any chance that they might be dismissed at the end of the disciplinary hearing. So if there's any chance that the allegation could amount to gross misconduct, that needs to be set out in the disciplinary invite letter, because the employee needs to be aware that that's a risk for them, so they're fully prepared for the meeting. Then there'll be a disciplinary hearing, and at that stage the disciplinary officer needs to listen to the employee's version of events. So find out what they say happened and consider at that point whether there needs to be any further investigation. So the employee could say at the hearing that some of the witness evidence isn't credible. There might be 2 witness statements that the investigating officer has taken that support the allegations, but the employee could cast doubt on their credibility. They might suggest that they weren't in work when those witnesses say they were in work. They might suggest those employees hold a grudge against them for some reason, and they might give names of other people who could back up their version of events. At that point, the disciplinary officer might need to investigate all of those matters so they have all of the relevant evidence. Once the disciplinary officer has done the full investigation, so they've done further investigation and considered all of the evidence and listened to the accused employee's version of events, they then need to make their decision as to whether the employee is guilty of the alleged misconduct, and also what sanction is appropriate. So is it gross misconduct? Should they be dismissed? Should they be dismissed without notice, dismissed on notice? Is a final written warning more appropriate, or perhaps a verbal warning? And they need to set all that out in writing to the accused employee. That outcome letter should be fairly detailed, so it should set out what evidence the disciplinary officer has considered and their reasoning and why they've made the decision. And that letter should also give the employee the right of appeal. The appeal is the final stage in the process. Obviously, the employee doesn't have to appeal, but they should always be given the right to. At that point, there needs to be somebody else involved, an appeal officer, and the appeal officer should always be somebody more senior than the disciplinary officer. So at the start of a process, if you're deciding who is going to undertake which stage, you need to consider who is going to deal with any appeal, because it needs to be somebody senior. The employee should be encouraged to set out their specific grounds of appeal, because those grounds of appeal will determine how the appeal officer deals with the matter. The employee might admit to the misconduct but suggest that the sanction was too harsh, in which case the appeal officer only needs to look at the sanction and what sanction was appropriate in the circumstances. Alternatively, the employee might suggest that the whole process was flawed. They might continue to deny the misconduct, in which case the appeal officer might need to do a full rehearing of the evidence. They might need to look at everything again and decide whether, in their view, the employee is guilty of the alleged misconduct. Again, there might need to be further investigation if something has happened between the disciplinary hearing and the appeal hearing, and the appeal officer needs to consider whether they need to investigate anything further, whether they need to speak to the disciplinary officer about why he or she made the decision that they did. Once again, the appeal officer needs to make sure they communicate their decision in writing to the employee and set out the reasoning behind that decision. After that stage, there's no further right of appeal, so that's the end of the process. Once the appeal officer has made their decision as to whether to dismiss the appeal or uphold the appeal. If they uphold the appeal, they might decide to reinstate the employee or have a different sanction. They're the three key stages of any disciplinary process, but obviously each process is different and there are often complicating factors. So it's very important to make sure that you follow a fair process, because the risk of not doing so is that you find yourself facing an unfair dismissal claim for which compensation can be awarded of up to around £74,000. So if you're considering, especially if you're considering dismissing an employee, it's important to make sure you understand the process to be followed and take advice if necessary to make sure that the process is fair.